the biggest civil rights case in American history, hands down. This is going to make Brown versus Board of Education look like small claims court, and and we did it completely in the silo, like without even people even knowing what we were doing, because I kind of had to stumble through the dark to try to figure out the best angles and stuff to do this, right? But so the issue at hand, what we actually focused on was the indictment, or the absence thereof of the indictment by a grand jury. That was the focus to be heard by the court. But the issue is much, much bigger. But so today, consider the Constitution, the overarching requirements that all states must follow. If the states don't follow the rules, then what they produce is unconstitutional. That's a pretty simple concept. So when the Constitution provides the specific steps to adjudicate a crime, and then they don't follow those steps, then that would mean that the judgment is invalid, because it derives from an unconstitutional act by a state. So the Constitution of the United States of America, Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You got to have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. An infamous crime is defined by Title 18, subsection 4083 as any crime punishable by more than 1 year imprisonment in a penitentiary. And it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to, because, again, the Constitution says you cannot be held to answer. So if you're being arrested for a crime that could get 5 years, but you only get 3 months, well, the arrest is what matters. If you're arrested for something that could get 5 years, that is still in the infamous nature. So it's not the amount of time you get sentenced to, but the amount of time you can be sentenced to. So there are currently 13 states in America that do not conduct a grand jury at all, including the state of Washington, who is the primary respondent in our litigation. So Washington State's Constitution, Article 1, Section 26 says no grand jury shall be joined or summoned in any county. So we have a state's inferior constitution that functions, provision that functions directly the contrary of the United States Constitution. Now we got a supremacy issue. So in the history of the state of Washington, they've never convicted a person legally and lawfully consistent with the procedures and processes established and codified in the Constitution, because they have a provision that is repugnant to the Constitution of the United States of America. Right? And that's a big deal. That's a big, big problem. So, yeah.
Most definitely. Now, with this, so this class action lawsuit, what is it all involving? You want to give us a little bit more details on it?
Yeah. So what we're doing right now is the origin of this issue, right? Where it started. Why is it that a state can act this law and get away with it for so long, right? And people not realize that there's an issue. Well, that's because the Supreme Court in 1887, in a case called Hurtado versus California, they came out and said, California, you don't have to have an indictment by a grand jury, because they wrote a provision in their inferior constitution that said we're going to charge by information, not by indictment. Information is not indictment. Indictment brings in a neutral, unbiased third party to review the state's accusations to determine whether or not there's probable cause. Information removes that neutral, unbiased third party and instead brings it to a judge. Well, the judge works for the same body of men that the prosecutor does, that law enforcement does, and it's going to be profiting off of the involuntary servitude of the person that's deemed an aberrant criminal, right? So there is no neutral, unbiased decision maker when you're dealing with what's called information. The state is your accuser and is accusing you of an arbitrary offense so that they can put you in an institution that we call a sweatshop in China, but they call a prison here in America. So this started because the Supreme Court of the United States came out in 1887 and sided with the state constitution, and thus fundamentally changed the guarantees or obligations of the Constitution of the United States of America. They said, oh, California, you don't have to do what the Constitution says. Well, that means that the Supreme Court of the United States altered the Constitution of the United States of America by a court that, by the way, was extremely biased and preferential to the slavery institution. Waite and his court were well known to be slave sympathizers. They put into place numerous rulings that undermined the Reconstruction Amendments, undermined the Constitution, and they made it into a charter of enslavement instead of a document that guarantees the individual liberties of the people by limiting the powers of government. They changed the Constitution fundamentally. In fact, Waite had made statements. We have statements from him that, such as, to make a black man and a white man eat together would be a whole other kind of slavery. He also made the statement that the 14th Amendment might be on the books forever, but we intend to make it a dead letter. These are statements that the Chief Justice of the United States Supreme Court made, and then we wonder why these rulings are in place. He sided with the state of California, thus changing and altering the Constitution through an amendment through judicial fiat, and then they called it case law. Well, the problem with case law is that judges don't get to create law. All legislative power is vested in the legislative branch. So when a judge creates a ruling, and that ruling fundamentally changes or alters the Constitution of the United States in other than lawful manner, because if you want to know how to change the Constitution, you will go to the Special Amending Procedure of Article 5. That tells you how to do it. Any other way is what's known as sedition. Because sedition is the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration in other than lawful manner.